Good morning, everybody. This is Diane Ewing, Vice President of Marketing and Business Production at Hoffman Brown Company. And we're so happy to have you attend our presentation of anti-harassment training in partnership with Symmetry HR Outsourcing, formerly known as RSJ Swenson. As mentioned in our invitation, this training satisfies the requirement of Senate Bill 1343, requiring all employers with 5 or more employees to provide anti-harassment training to all employees every 2 years or within 6 months of hire. We're so grateful to our partners at Symmetry HR Outsourcing for continuing to make this training available to our current and future Hoffman Brown clients free of charge. Just a reminder that this morning's training will be 2 hours and is intended for management and supervisory employees. Please note that after the webinar, you're going to receive an email from Hoffman Brown Company confirming your attendance today. It's very important for you to keep that email because that's your confirmation of attendance. There will be no certificates of completion given after this presentation. And I just want to say that one more time because I get a lot of questions about this. There will be no certificates of completion given, so please be sure to keep your confirmation email that you will receive approximately 1 hour after the presentation ends. I wanted to let everyone know your phones are in muted mode, so we can't hear you, but because the training is interactive, we do encourage you to ask questions. And to do this, just go to the Go to Webinar panel in the upper right-hand side of your screen, and you'll see the box where you can type in your questions. We'll try to answer as many of them as we can during the presentation, but the follow-up email that I just mentioned will also have Devon's contact information so you can reach out to her afterwards. And speaking of Devon, we're thrilled to have Devon Deshala of Symmetry HR Outsourcing hosting today's presentation. Devon has been with Symmetry for more than 3 years, and she's hosted many of these trainings for Hoffman Brown clients. Devon's a human resource consultant, and she joined Symmetry after more than 14 years with the Department of Veteran Affairs Greater LA Healthcare System, where she rose all the way to Interim Director of Employee and Labor Relations, overseeing more than 5,000 employees. Devon has detailed knowledge of the ins and outs of human resources, as well as both federal and state labor laws and issues. So she's definitely qualified to do this presentation, and I will now turn it over to her.
Good morning, everybody. Thank you so much for being present today, and thank you, Diane, for that lovely introduction. Diane had a little bit of feedback on her phone. I'm hoping that that's not the case for my audio, so please let us know if for some reason you cannot hear us properly. We'll try to troubleshoot it. As Diane mentioned, this will be a 2-hour presentation that we understand may not be a topic that everybody is very excited to listen to at 9:30 on a Wednesday morning, but it's a topic that I'm really passionate about, and one that I think we all really need to pay attention to and look towards the future. I want this interaction to be as entertaining as possible, but also very interactive. So there is a chat function on the control panel, and Diane will be monitoring that, and I'll try to monitor it as well. So if you have any questions throughout the presentation, please feel free to let us know so that we can address it. If you need any clarification on a slide, we want to make this presentation as valuable as possible to you all. So as I said, non-harassment training is something I'm personally very passionate and proud to talk about. I'm also particularly excited because for the last 7 months, we have been, my firm has been very focused on advising clients on how to survive and manage COVID. So it's nice to be able to talk about a non-COVID related topic. That being said, we also recognize that a lot of companies are looking a little different these days as a result of COVID. So whether you are completely remote or doing a hybrid of remote and on-site, we are going to try and make sure that this training program also touches upon how remote working and some of the challenges with COVID need to be tailored for the training that we're providing today. So we'll try to talk about that. with the overarching theme that these policies, this responsibility as managers to safeguard environments, work environments of your employees, extends not just from the physical work site of your company and organization, but also to your employees' remote work site. So the same rules, logic apply when you're on Zoom or Microsoft Teams or other online platforms. So prior to COVID, when I would provide these trainings in person, which I miss dearly, the human interaction, I would start by asking the group why they think we're here today. Why have we asked you as managers, as supervisors, as leaders of your organization to give up 2 hours of your time to listen to me talk about non-harassment? And a lot of responses involved, well, I was told I had to, that legally I had to attend this training, or my company, made sure we were compliant with the law. And some answers were a little different. Some answers recognize the importance of this issue, especially in the last few years, right? Since 2017, 2018, we've seen a surge of harassment and sexual harassment outside of workplaces and inside of workplaces. And it is reminding us as a society that this issue is still extremely prevalent. And I know it's difficult right now when we've got our COVID blinders on, but it's important for us as managers not to forget that we have a responsibility as a manager, as a leader. A company has a responsibility to create a safe work environment for our employees and protect them and try and prevent harassment from occurring in the workplace. And so really that's what this program is geared to talk about today, to talk about both an organization's responsibility to try and create a safe environment, but then also talk about if harassment still occurs, what is our responsibility? What is our liability? How do we handle it? So that's the focus for today's program. So, quick overview of what we'll talk about. First, we'll look at the definitions of unlawful sexual harassment under both federal and California law. And once we've defined it, well, what does it look like? It's great to have a definition, but how do we actually recognize harassment in the workplace? And again, we're going to have to kind of be more creative in how we think, because it's not just now when you walk through the halls and you're monitoring what your employees are doing. Now you've got a remote work site. So now you have to think about what's happening on a Zoom call. So how do you recognize the harassment? And then your obligation as employers, which we talked about. The idea that first and foremost, you're obligated to try and prevent harassment from occurring in the first place by creating that safe environment. But if for some reason harassment still occurs, how do you correct it? How do you investigate it? What steps do you take to correct it and make sure that the parties are protected? We'll also talk about abusive conduct. This was sort of the hot topic about 5 years ago, called bullying. Remember, bullying is not just in schools, but bullying is also in the workplace, some of those taglines. So we'll define what abusive conduct is and talk about some strategies and how to, again, prevent that from occurring. We'll look at the grievance procedure. So what system has your organization developed so that if an employee feels they've been harassed or witnessed harassment, they understand who to go to? How do they report it? And then how does your organization take that information and investigate it? Who's responsible for investigating it? Who's responsible for reviewing the findings, etc. We'll talk about limited confidentiality, the idea that an employee cannot report a complaint anonymously, that a company will certainly try and safeguard their name as much as possible, but they can't report it without providing the name and information about what they may have witnessed or experienced. We'll also talk about retaliation. Retaliation is the idea that an employee may have made a complaint of harassment or may have witnessed harassment and participated in an investigation. And then later on, perhaps there was some type of action taken against that employee. They may have received a poor performance appraisal, their schedule may have been changed, and they may attribute that to their participation or their complaint of harassment and say, you're retaliating against me. So how do organizations We'll also then take all of this overarching information that we're throwing at you and then talk about actual strategies. What are things that you can actually do in your organization to prevent harassment from occurring? And finally, just to tie everything together, we'll go over some what would you do scenarios. If this occurred, how would you properly handle it? So as Diane mentioned, and I said at the very beginning of the presentation, there is a legal requirement as to why you are all here. In California, there was a law passed, AB 1343, and that law previously required that larger organizations, organizations of 50 or more employees, provide non-harassment training to managers, supervisors, leaders. And so many of you who have been in a leadership position or supervisor for many years, you've probably already attended a similar presentation, or perhaps you've heard me speak before. However, 2 years ago, Senate Bill 1343, which went into effect in 2019, was passed. And that Senate bill stemmed directly from the Me Too movement that was occurring at the time. And it basically said, you know, in California, we're not doing enough. By just requiring managers and supervisors to be trained every 2 years, it's not sufficient. We need to do more. And so Senate Bill 1343 changed the regulations, and now smaller companies, so now any organization with 5 or more employees, are required to provide the same training for managers and supervisors every 2 years, so that component doesn't change. And any new supervisor has to be trained within 6 months of being hired into that position. But it also requires that all employees who are non-management also receive training. Now, their training is a little different. It's 1 hour, and it's still every 2 years. And it's focused on understanding what harassment is, understanding that employees, they are entitled to a safe environment, and being educated on their recourse. How do they report it? Who do they report it to? What they can expect from their company. And if for some reason they don't feel that their company addressed their concerns appropriately, they have the option to file a complaint with both the state of California, Department of Fair and Equal Housing, or federal complaint with EEOC. So the idea was every single individual who works in a company of 5 or more employees in California needs education on this topic. The training has to be interactive, so we can't just send out a video or send out a PowerPoint. There needs to be an opportunity for the participant to ask questions, so either in person, although we probably won't be doing in person for many more months, or a webinar such as this where you can type in a question or email after. Obviously, there's special requirements for trainers as well. So usually it's a lawyer or subject matter expert or HR professional such as myself. So before we get into the meat of the presentation, I like to start with a few true or false. Again, this is a lot more fun when we are in person and I can gauge the audience, but we can still do it over a webinar. These are just to kind of get you thinking about certain topics with harassment law and sort of see where your knowledge base is at. So first one, managers are liable for the actions if actions are within course or scope of their job of individuals under their control. So are you as managers liable for what your employees do when they're serving as an employee? So typically prior to COVID, we would say when they're on the work site or when if they're off the work site, still acting as an agent of the company. Are you liable for what they do? And the answer to this is yes, absolutely. It's your responsibility to make sure that employees are acting professionally and appropriately and they're not engaging in inappropriate behavior. Again, it's very easy to do this when you're on site. You're able to see your employees. This becomes a challenge when your employees are remote. If you have an employee who's on a Zoom call, they're wearing something inappropriate, they're saying something inappropriate, or maybe they even have an inappropriate picture in their backdrop. You're responsible for that if it's a work-related Zoom call. So these ideals and these responsibilities transfer to the remote world as well, as if you didn't have enough to manage these days, right? The next one, if your intentions are good, your behavior cannot be considered sexual harassment. So great example is if an employee comes to work and maybe they have had their hair cut or they're wearing a new outfit, and another employee wants to give that individual a compliment, but in doing so may look them up and down, may make some comments about their body, use some sexual terms like you look sexy, or certain terms that fall into that inappropriate category. Now, the individual who made the comments was just trying to give the other individual a compliment. Their intentions were good. But could that behavior still be considered harassment? And the answer is obviously yes. The idea here is it is not someone's intentions, because remember, humans have a large spectrum where they may fall in terms of what they think is appropriate and what they don't think is appropriate. Some people might be very free and not offended by anything that is said, and others may be on the other side of the spectrum and may find a lot of things offensive. The law has dictated that what we look at is what a reasonable person, we're going to talk a lot about this, the idea of reasonable, what a reasonable person would perceive as harassment, regardless of intention. So it's not somebody's intention, but it's the perception of the behavior. Would a reasonable person find those comments to be offensive? And that's sometimes difficult for employees to understand. And we talk about this when I do the employee portion or the employee presentation, that they have to recognize that when you're at home, you may act a different way. But when you're in the workplace, regardless of your own personal beliefs of what you find offensive and don't find offensive, you have to put on that professional hat and try and remember it doesn't matter about your intentions, it only matters how it's perceived, and to stay in that area. Not being aware of current state and federal law is okay. After all, you didn't know, right? Can you fall on that? Can an employee fall on the, well, I didn't know that sexual harassment wasn't allowed in the workplace? And obviously the answer to this is false. And California in particular has created these laws to make sure that an individual cannot fall on this, because again, they're required to receive training. There's no reason for an individual to be able to even say, I didn't know, because all employees should receive some type of training. Asking a coworker for a date is not sexual harassment. And I always pause on this one because a lot of people get tripped up on this. So the statement as written is true. There's a couple pieces to understand here in California. So first, in California, you cannot have a policy, company cannot have a policy that prevents employees who are at the same level from having a romantic relationship. Now, you can certainly have a policy that prevents an employee and a supervisor, even if it's a supervisor in another department, from having some type of relationship. When there's a difference in level of the organization, and that may impact the ability to supervise or lead, then certainly you can prevent that. You can have a policy that says the company doesn't support that. But you can't prevent the inter-office dating. Now, as an HR professional, I hate seeing this because unfortunately, they estimate that 50% of sexual harassment claims in organizations actually stem from consensual relationships that have soured, right? Dating is messy. And if it doesn't continue or turn into another form of commitment, then if there is a breakup, it can be uncomfortable in the workplace. So as an HR professional, you never want to encourage inter-office dating, right? You don't have to encourage it by any means, but you can't have a policy that prevents it. The other piece to this to understand is how you ask somebody out for a date, because that can change the scenario. So I'll use this example, and for those of you who have heard me speak before, it's a very simplistic example that I use throughout the presentation, but I chose it just because it's very easy to change the different options. But let's say you have two coworkers. They're at the same level in the company. There's no supervisory relationship. We'll call them Joe and Jen. And let's say Joe wants to ask Jen for coffee. This is pre-COVID, where we're still on site in break rooms and able to have coffee inside. So Joe sees Jen in the break room, says, "Hey, what are you doing Saturday morning? Can I take you out for coffee?" And Jen says, "Thanks, but no thanks." And Joe leaves it alone. He doesn't bring it up again. Is that harassment? Probably not, right? He was polite. He left her alone when she said no thank you. But let's change the scenario. Let's say that Joe doesn't want to take no for an answer. We can also flip the dynamics here and make Jen be the one to ask Joe out. We can make it gender neutral. We can have two females, two males. Again, I want to make sure we're throughout the presentation not, we're being gender neutral in this. I just happened to choose Joe and Jen. Let's say Joe says, "Well, I'm going to ask her out again." And he asks her out again in the break room, or sends her an email, or puts a post-it on her desk, or stops by her office. He continues to ask her out, and it makes Jen very uncomfortable. Is that harassment now? Absolutely. So in understanding this statement, it's important to understand the two pieces, which is there some type of supervisory subordinate relationship going on? And also, how are they asking them out? Many of you, it's just common sense. If you ask more than once and start to bother somebody, then yes, that's become harassment. And we'll talk more about this in this example throughout the presentation. Next one, men as well as women may be either the perpetrators or victims of sexual harassment. And obviously this one is true. Gender does not play a role. A male can harass another male. Female can harass a male. Somebody who does not identify with being male or female can harass the same individual. It doesn't matter. Gender does not play a role in determining whether it's sexual harassment or not. We look at the behavior. Sexual harassment is only prohibited if it occurs in the workplace during working hours. And this one's false as well. So again, prior to COVID, when we were mostly on site in companies, if it was on site, what about holiday parties, or if teams have team dinners or they travel? Anytime that it's somehow a company event or work-related event, regardless of being on site or during working hours, the organization is responsible. In fact, in 2017, when we started to see all these allegations in the news, a lot of companies got really nervous right around October, November, and they decided to cancel holiday parties or make them a dry lunch, right? They did not want to take the chance of having a late night event with an open bar where things could go awry. Again, probably are not going to have that problem this year, but absolutely, it doesn't matter if it's on site or after working hours. If it's somehow a work event, then you as the manager and you as the company are responsible for what occurs. Now, unfortunately, there is a lot of gray area with this. The law does not have an extensive list of if this, then yes, you're responsible. If this, then you're not. My particular experience, I have seen some clients struggle with events that could go either way. And what I mean by could go either way, you could argue the company's not responsible, but they ended up being responsible. So I'll give you one example. I had a client where there was an employee happy hour, and it wasn't coordinated by the company in any way. Work was not discussed, but it did happen to be a group of employees, and they didn't even have supervisors there. And there was an incident, and the company was made aware. The employees did report it, and they actually did act accordingly. They were more conservative and did get involved. But other companies may have looked at it and said, well, it wasn't company sponsored, supervisors weren't there, these were just their own employees who happened to gather outside the workplace. My advice in this is, when in doubt, always consult with your counsel. So if you as a manager, no matter where you are in the organization, if you receive a complaint from an employee about something that has happened off-site, and you may think, we aren't liable for this, this isn't our responsibility, I would always bring it to your HR or follow the chain of command in your organization and have some kind of legal review of the situation. Because what you don't want to happen is you make that assessment, it escalates, and then for some reason it becomes a lawsuit, and in the lawsuit it comes out the organization was aware and failed to act accordingly. Like I said, it's a very gray area. It's not black and white about whether a company is liable or not. So always err on making sure HR, your executives, there's somebody else who's getting involved, as well as legal, and saying, yes, we should be responsible for this. We should be doing the investigation and going through all the motions, or no, we're not. Because I would hate for a manager to then later on have to deal with, well, I knew about it and didn't report it accordingly. So not to scare you all, it's just the climate that we're in. It's always better to have multiple sets of eyes and opinions about whether to get involved on something. And the last one, a single complaint means that no investigation is necessary. You need more than one complaint to investigate. True or false? And obviously that one is false, right? For bullying, which we'll talk about, hostile work environments we'll talk about, you generally will see a pattern but you don't have to have multiple incidents. One incident alone, one complaint alone is enough to initiate an investigation and to determine that there's been some type of harassment. So with that, we'll get into the meat of the presentation. So federal law against sexual harassment evolved from the Civil Rights Act of 1964, and the Equal Employment Opportunity Commission enforces it. All this slide means is that employees have federal protection from harassment. So again, employers in California, an employee may file a complaint two ways if they feel that the company hasn't responded appropriately. So we'll talk about a company's response later on. An employee always should try and deal internally. They should always report it internally and allow the company an opportunity to handle it first, right? They should never just jump to filing a complaint. But if for some reason they don't feel that the company has acted appropriately, they can file with the state. They can file with the California Department of Fair and Equal Housing. And the law has changed with how long they have to file. It used to be 1 year. Now they have 3 years from the date the incident occurred, 3 years. So if it occurred December 1st, 2018, if I do my math correctly, I don't think I'm doing my math correctly, 2017, then they would have till December 1st of, November, the end of November to file this year, so 3 years. They can also file at the federal level with EEOC. That time frame has changed as well. It used to be 180 days. Now they have 300 days. So things to be mindful of. Hopefully you don't encounter this, but things to just understand. So if there is federal protection from sexual harassment, how is it defined? It's defined as unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature constitute the harassment when the conduct has some type of impact. So when you look at harassment, it's not just the behavior, but it's also what impact did that behavior have? And it's one of 3 areas. So let's talk about that Joe and Jen example. And let's change it. Let's actually make it Jen asking Joe out on a date. Jen goes, she asks Joe out. He says, no thanks. She's persistent and keeps asking him out. Joe gets to the point where he's really uncomfortable. He doesn't want to go to work. He doesn't want to run into her. Again, pre-COVID. And, you know, he just decides, I don't need this anymore. The company's not doing anything about it. I've let them know that she keeps bothering me and they're not intervening. I don't want to have to deal with this. I'm going to quit. Going to find another job somewhere else. So he does. That behavior that Jen exhibited now impacted his employment, right? It explicitly or implicitly affected an individual's employment because he's no longer employed. Same example, but let's say Joe doesn't quit. Needs the job, decides that he is going to just put his head down and go to work, but he's distracted. He's making mistakes, he's missing deadlines. So now it's unreasonably interfered with an individual's work performance. Or same example, but we'll change it just a little bit. Let's say Joe and Jen do go out on that date and they're very happy, they become a couple. It's all over Instagram. But unfortunately, they bring that romance to the office and they're in the break room and they're talking about their romantic weekend away, or showing inappropriate pictures, or maybe they're physically interacting inappropriately. And another individual sees it and is uncomfortable. Now it's creating an intimidating, hostile, or offensive work environment. So again, the idea is you have to look at not just the behavior, but what's the impact that it has had to the individual. Does it impact their employment, their performance, or just the general work environment? In addition to protection at the federal and state level from harassment, there's also protection from discrimination. A lot of you are already familiar with many of these classes. There are, as much as I have done this presentation, I still have to have a cheat list of all of them. So we'll go through them very quickly. So there's protection from discrimination based on sexual orientation, gender identity and gender expression, race, color, ancestry, national origin, religion, sex, medical conditions, AIDS, HIV, disability, age, 40 and above, genetic information, marital status, military or veteran status, political affiliations or activities, and status as a victim of domestic violence, assault, or stalking. There are quite a few categories here. What this means is that you as a manager, you as an employer, cannot take an action against an employee because of one of these protected classes. So you cannot fire someone just because they are 45 years old. You cannot give someone a poor performance appraisal just because they are Jewish. You cannot demote somebody because they have a physical disability. Now, as managers, it's not just your responsibility to create a safe work environment, but the majority of your role as a manager is to manage your workforce, is to make sure that your employees are effective, efficient, and productive workers. So you're going to have to make difficult decisions. There may be times where you're going to have to give an employee a poor performance appraisal, or demote them, or fire them, or change their hours. I really like to stress on this slide because I have a lot of experience with managers who are scared. They are scared of an EEO complaint. They are scared of some type of legal activity because they are more proactive in managing. And that happens. When I worked at the federal government, just to give you some context, my agency that I was responsible for had about 5,000 to 6,000 employees. And we had a very large HR department. We also had a team of about 3 employees, full-time employees, and their only responsibility was to deal with EEO complaints. That's how many EEO complaints we received. Now, federal is very different than the private sector. My point is, the system is set up to allow employees to voice their concerns. And so you may see a lot of individuals who may make allegations of discrimination. The system is set up to make sure that they have a place to voice their concerns. It doesn't mean they're valid. But just as a manager, don't be scared if you receive some type of allegation that you've discriminated against an employee, if you haven't, obviously, because again, that's how the system is set up. Now, as a manager, you have to effectively manage. You have to make those difficult calls. Where I'm going with this long tangent is that when you do those, when you do have to give someone an uncomfortable performance evaluation, or you do have to fire an individual or give them some type of disciplinary action, you do it based on one of 2 reasons. The employee's performance, right? Or the condition of the company. So if you have to do a layoff, it's either, if you're firing someone, it's either because they're a poor performer or they've had misconduct and you've tried to correct it. It's not correcting and you need to let them go. Or you're doing a layoff, you no longer need that position or that employee. You're not doing it based on one of these protected categories. And the most important part of all of this is to document that. Because sometimes employees when they get bad news, right? We all human nature. If we get a poor performance appraisal, we get disciplinary action, or our hours are changed, sometimes we may look for other reasons as to why that occurred, rather than recognizing that it was because I'm a bad performer. So they may look to trying to make a claim about discrimination. So it's so important for you as a manager to have fully documented your reasons why. So that if you do, and again, not to scare you, but if you do get some kind of allegation, you have the documentation to fall back on. Well, no, actually, we terminated you because we had given you 7 counselings already on being late to work, or whatever the issue is. So I just wanted to take a moment to talk about that this slide is not meant to scare you into being submissive as managers, because that has happened. I've seen a lot of managers who just go, I don't want to deal with it. I'm too scared of getting a complaint. Rather than being proactive in managing their employees, but doing it for the right reasons and documenting those reasons. Transgender is also a protected category, term used to describe people whose gender identity differs from the sex they were assigned at birth. People who identify as transgender are protected, right? A transgender person does not need to complete any particular step. So all they have to do is just simply say, I am transgendered. They don't have to have gone through any physical or mental changes in order to be protected by the law. So again, employees and individuals are protected if they are actual members of the category, right? It also extends to members who are perceived to fall into one of those categories. So you could make the argument that I'm not over 40, but I could say my manager has perceived me to be 45, and therefore that is why they demoted me, right? Or you're perceived to be a certain ethnicity. You can make that argument. A person who is associated with a person who has or is perceived to have any of the protected characteristics. So if you're married to someone, an employee could make the argument that they're being discriminated against because of who they're married to. So we've talked about discrimination. We've defined federal harassment. Let's talk about what it actually looks like in the workplace. How do you spot it, right? Again, both on-site and now remote on Zoom and all of those platforms. So there's 5 types of harassment. The first one is verbal, which include derogatory comments, racial or sexual epithets, jokes, stories, and then also nonverbal. Staring, derogatory suggestive gestures, winking, throwing kisses, shunning, ostracizing. Visual, offensive pictures, photos, cartoons. Again, anything that you have in the work site or in your office, you may find a piece of artwork that speaks to you, but if a reasonable person would look at that and be offended, then it's inappropriate for the work site. This also extends to your Zoom. Now that everybody's at home, it's important to remember that their backdrops, that they've chosen an appropriate backdrop. They don't have the TV going with something inappropriate or posters, that they're also dressed somewhat appropriately. I know that's sort of lax these days. Everybody's wearing pajama bottoms and perhaps maybe more of a professional top. You know, I will share a personal experience where, you know, I have a 3.5-year-old who's home, and I was on a big call with one of my favorite clients, and in the middle of the call, of course, my daughter needed her tap shoes on for ballet, and I thought I had politely turned the camera off while I ran to deal with her. Unfortunately, I hadn't. I turned the camera exactly to where my daughter was, and I was furiously trying to throw on her cat shoes and get back to this conference call, and I was all frazzled. And things like that happen, right? We all are trying to juggle so much these days. And so, it's important for employees to understand that they know how to properly use their Zoom and turn their camera on and off, because they may inadvertently be wearing something not appropriate or have something in the backdrop that's not appropriate, and that could offend somebody else. Physical, again, probably not going to have a problem with this for the next year or so, but it could be unwelcome touching, hugging, kissing, patting, stroking, standing too close. These are types of behaviors that could be offensive to some. Hugging is one I want to talk about for a second, because a lot of clients always are surprised by this. Less so now, but I think a few years ago when I started to do this presentation, one client in particular, who they're an organization that is centered around rehabilitating its employees, and their culture is all about hugging. They hug throughout the day. They're just a very close organization. And so I was giving this presentation, and I felt like I had just told them Santa didn't exist, when I said hugging could be construed as harassment. As I said before, so much of harassment falls into that gray area. There simply isn't a checklist or giant book of behaviors where it says clearly this is harassment or this isn't. Hugging is one of those. Prior to joining the RSJ Swenson, or now HRO Symmetry HRO, when I was at the federal government, I had been there for 14 years and worked with the team for 14 years. Very small team, and we were like family. For us, there were occasions where it was absolutely appropriate to hug. When I got engaged or had a baby, things like that. You have to do a couple things when you look at these gray area types of behavior. You have to look at, again, the idea of would a reasonable person find it offensive? And you also have to encourage your employees to do two things. To use their common sense. Most individuals can gauge when a handshake is not going to be appropriate or when a hug is not going to be appropriate. And also for employees to feel comfortable to go to you as a manager, or even to the employee, to say that something makes them uncomfortable. I will give you an example. So as I said, when I worked at the federal government, I was on in a small team. And there was one employee who was relatively new and was just a little less friendly, wanted to come do his job every day, didn't really want to have that personal relationship that we had on the team. And that was absolutely okay. So when I was the supervisor, the individual came to me and said that when he saw other coworkers giving a hug occasionally, it made him uncomfortable. Well, number one, that was so great that he felt comfortable enough to talk to me, that as a manager, I had created a strong open door policy, right? So that I could correct that situation right away. And it was very simple. I simply let employees know, quietly. I didn't have a big staff meeting about it. I just let them know, hey, this makes some individuals uncomfortable. Let's not do this in front of other employees. And that was it. The employee who made the complaint appreciated that I handled it, and it never turned into some type of claim of harassment. My point in bringing up this example is that as managers, you want to, first and foremost, make sure that you have that open door policy so employees can let you know, right, if something makes them uncomfortable. you want to encourage your employees to use their common sense, right, to gauge what might cross the line. Those are all things that you as the manager can do, right? Having an employee voice a concern to you and you dealing with it right away, that may take 10 or 15 minutes of your time, but will save you hours and hours and hours of heartache and time, and perhaps even resources and money if you ignore it and it turns into a claim in the future. The last type of harassment is written. It includes unwelcome personal letters, notes, or emails. Not sure we write many letters these days, but certainly emails to individuals. And we'll also talk about texts, right? And the difficulties in employees and managers who utilize text in just a moment. But I want to talk first about some statistics on sexual harassment. You know, I said in the beginning of the presentation, this is still incredibly prevalent in our workplaces as well as just in society. But here are some statistics to kind of drive that point home. 40% of all EEOC complaints are unlawful harassment, and 45% of those complaints are sex-based. 30 to 40% are retaliation, which is a large number. And what that number will do is, if we have 30 to 40% of these claims stemming from retaliation, it's going to create a culture where employees are just not going to report the complaints because they're worried about retaliation. So of these statistics, this to me is the most concerning. At least 25% of women experience sexual harassment in the workplace, and 75% of harassment victims experienced retaliation when they reported the harassment. So again, those retaliation statistics are what are the most concerning to me. Somewhere between 87 to 94% of employees who experience harassment do not file a formal complaint. So in a minute, we're going to look at the number of complaints that have been filed. And if only a fraction of employees are actually reporting it, then you can do the math and see that it is still so prevalent in our workplaces. If you're a woman, you have a 60% chance of experiencing sexual harassment in general, whether on site or just in society. And if you're a man, you have a 20% chance. We can't confirm, but we actually hypothesize that this is actually low, just because in general, men are less likely to report harassment. We suspect that it's actually higher. And these are pretty scary statistics. And hopefully by mandating, at least in California, that employers and employees are trained and aware, we can shift the culture, shift it, and hopefully see a drop in these statistics, shift it to where they don't become part of our cultural norms. There are one case in this presentation and one graph. I promise I won't bore you with anything more. But actually, this is a really interesting graph that shows the number of sexual harassment cases filed in the United States. And you'll see this captures data from 1991 till 2018. So we still don't have our 2019 and obviously finishing the 2020 data. You will see a very large, move my box over here so it's out of the way. You'll see a very large increase from 1991 until it peaks around 97. It comes down a little bit 2005, 2006. 2005, 2006 was right before the recession. So a lot of individuals were less likely to report claims at that point because they were afraid of losing their job. So, you know, again, it's hard to tell whether the claims are going down or just they were less likely to report it. Levels out. starts to rise again in 2018, and we expect to see a huge uptick again in 2019 as a result of what's been going on with the Me Too movement and the media. So what happened in 1991? There's a huge increase in 91. Now again, this is not the number of cases or the number of actual harassment occurring. It's the number of cases being filed. So it's not like all of a sudden in 91 and 92, individuals lost their morals and were starting to be inappropriate in the workplace. It just means that's when people were starting to report it. So what happened? Sometimes I will tell you, when I do this presentation, everyone sort of always says Bill Clinton is the answer, and that's not the answer. But in 91, Clarence Thomas was nominated to the Supreme Court. And at the time of his nomination hearing, Anita Hill, who had worked with him at the University of Oklahoma, came forward and said very publicly that she had been harassed by Clarence Thomas when she worked with him. Now remember, in 91, this was before smartphones, before the age where news traveled rapidly, where primarily individuals got their news from the television. And so I believe it was over the course of 2 days, Anita Hill testified, and it was all televised and it was broadcast throughout the country, and in very graphic detail described her experience working with Clarence Thomas. And what this did is two things. Number one, it defined sexual harassment. It pushed out the term sexual harassment throughout the country. Now all of a sudden in living rooms, people were listening to this term. And a lot of individuals were sitting there listening to her story and saying to themselves, gee, that's really similar to what I'm experiencing at my workplace. I feel I'm going through the same thing. And now all of a sudden it has a name. It's called harassment. And number two, it showed that there was something that people could do about it, that there was recourse, that they could file a complaint. And so that's why we think there's this huge uptick in complaints being filed, because it pushed out that idea. It allowed people to be educated on the term and educated individuals on the fact that they could do something, they could actually complain, that they didn't have to just be subjected to this. So again, that's just sort of some history about the number of cases that's filed. We can really only look at what's been filed. We can't, we can take statistics and go, well, if we know only 87 to 94% of people file claims, we can try and get a better sense of how many incidents are actually occurring in the workplace, but it's difficult to get those numbers. But overall, no matter what, these numbers are simply too high for where we are at. We should not see these numbers in our workplaces. So when we talk about protection from discrimination and talk about protection from harassment, the discrimination complaint or discrimination protection, that applies to employers with 5 or more full-time employees. But the anti-harassment provisions apply to employers with 1 or more employees. So that's just the difference in terms of the protection. The smaller companies with 5 or more only have to, or 5 or more, in companies with 5 or more employees have to adhere to both. But if you're under 5, apparently you don't have to adhere to the discriminatory claims. So we've talked about the federal definition of sexual harassment. What is the state's definition of sexual harassment? And it's very similar. It's unwanted and unwelcome visual, verbal, or physical conduct that is sex-based or of a sexual nature. request for sexual favors, or offensive third-party conduct to which the victim is subjected. And I want to pause here for a moment. I want to talk about third-party conduct, or talk about the idea of, well, who is protected? Is it just employees, or does it extend further than that? So I'll give you an example. Let's say you have an office setting, again, pre-COVID, and it's a large office and they receive shipments every day from various couriers. And let's say it's the same delivery person from, we'll use FedEx in this example. It's the same FedEx driver that comes every single day. And the office setup has one individual who sits at the front, an assistant, receptionist, whatever title you want to give the individual, and they receive the packages. And in this example, let's say a manager notices that the FedEx delivery person lingers at the front desk. Maybe the manager even overhears the FedEx delivery person make suggestive comments to the receptionist. The receptionist assistant does not complain to the manager, doesn't say anything, but the manager hears enough to know that what is being said or their physical gestures are inappropriate. What should that manager do? Should the manager just say, well, that's the behavior of a FedEx driver and they're not my employee and there's nothing that I can do about that behavior, and I'm just going to ignore it? Also, the receptionist hasn't complained, so why would I get involved? Is that the right response? And the answer is no. So a couple things with this example. Number one, it's important to understand that a manager and organization is responsible for protecting the work environment, which means anybody who comes into contact with that work environment needs to be professional and appropriate. It doesn't matter if the individual is not an employee. So if you have a vendor, such as this FedEx delivery person, maybe you have a job applicant that comes into the office, or a client, customer, anybody who comes into the work environment needs to be held accountable to these standards. Number one. Number two, and we're going to talk about this idea later on, but we'll touch upon it now. Oftentimes, employees who are subjected to harassment don't report it. And if they don't report it, but the company is aware that it's going on, is the company still liable? And the answer is yes, absolutely. And we'll talk about the reasons why employees are less likely to report harassment. So in this scenario, what the manager should do is, number one, talk to the receptionist, okay? Talk to the receptionist, let them know that they overheard the FedEx delivery person, that the behaviors were not appropriate, and that they were going to deal with that behavior. And it is difficult and challenging when you're dealing with behavior of someone who's not your own employee, right? Because you can't discipline the FedEx delivery driver, but you certainly can protect your employee. You can call FedEx and say, send another driver. You can complain to FedEx. You can tell the driver to leave the packages at the door. There's lots of different creative ways to solve the problem, but the solution needs to be that that FedEx driver is no longer inappropriate with your receptionist, period. Even if the receptionist hasn't complained. Because somebody else may overhear it as well. You may have another employee who's in close earshot who hears that and is offended. So again, as a manager, you need to be proactive in safeguarding that environment. Oh, now my slides don't want to work. I think I need to click here. So how do you recognize harassment? In the last example, we talked about the importance of managers being proactive. Part of that is not just waiting for an employee to make a complaint. That would be so nice if we could just rely on employees coming to your door with an allegation, with it written, with the names of the individuals who were involved, when it occurred, examples. That would be great if it was presented with a nice bow on it. But that doesn't happen most of the time, right? You may hear rumors that you have to deal with. You may hear it from other employees, or you may hear and see it yourself just as a witness, right? And so how do you recognize it? You want to look for unwanted sexual advances, visual conduct, verbal conduct, written conduct, physical conduct, and other types. I'll give you another example. When I was a manager for the federal government, I had a manager come to me and said that they happened to notice just in their observation, and in this case it was a male employee who, when the individual was speaking to somebody else, oftentimes would stare off into space because they were processing things. My husband does this all the time. He thinks about something, but he kind of looks off to the side. Totally normal behavior, right? People are thinking and they might look in a different direction. Unfortunately, this individual was doing so when speaking with female employees at their chest. None of the female employees were complaining, but the manager picked up on this. And the manager was a good manager and ended up being proactive about this situation. Recognized that it was enough of a red flag that it needed to be dealt with. And had a very polite, professional conversation with the male employee, happened to be a male employee, and said, you know, I'm not sure if you even recognize you're doing this, but when you're processing something and you're looking a certain way, you happen to be looking at the chest of a female employee. The male employee was so apologetic, number one, and also very grateful because he did not realize that he was doing this. He truly didn't know. Thanked the manager profusely. Maybe this conversation lasted 5 or 10 minutes. And after that point, the manager watched the situation and it never happened again. It was resolved. The reason I bring that up is to show the importance of being proactive as a manager. When you see those situations, and in this case, all it took was a 5 to 10 minute conversation with that employee to correct a behavior. It didn't have to wait until all of a sudden you have a bunch of unhappy employees who feel uncomfortable with this other individual, who don't want to work with that individual, who are getting really frustrated and they're filing complaints. And now you have to, as a manager, do an investigation and you've got to deal with all of these employees and it impacts the team dynamic, and what a mess, right? It is so crucial, and I absolutely understand it is very different for me sitting here giving you this information. I recognize that managers have so much on their plate, especially right now. I absolutely get it, and I don't want to downplay that, but I really encourage you all. I know it's so hard to find 5 extra minutes at the end of the day, but I really encourage you all to remember, if you can, please, when you see those issues that need correcting, to do so, to address them then and there at the lowest level before it turns into an ugly mess that's going to cost you 10 times as much time and resources and perhaps money later on. So just remember that one example. Again, this is also difficult to do when you're managing a remote work site. When you don't have eyes and ears on your employees. So when you're on the Zoom call, you can certainly monitor how people are interacting on Zoom or Teams or whatever platform. You also may want to take the time to let employees know that you may not have a physical door that they can go to anymore, but that it is still important that we are professional and that they feel safe in their work environment, even remote, and that you're there for them to voice any concerns. Take a few minutes to just remind employees that, or check in with employees. Those are all really helpful things that you can do, again, to try and mitigate and prevent escalated harassment claims in the future. So we talked about the 5 types of harassment, with the last one being written. And so what is the latest issue? Textual harassment. I did not create this slide deck. I know this is super cheesy. You can blame my boss for that. But it is actually a very difficult, it's a very prevalent issue right now. I just dealt with a client. They had actually 2 incidents of issues with texting between employees or between managers. So I want to take some time to talk about this. And we cover this when I talk to the employee and I do the employee portion of this harassment training. Number 1, emails and texts last forever, period. Any IT person on this call can confirm that no matter if you think you've deleted it or put it in some kind of black hole, it can be discovered, right? There are teams at cell phone providers, and all they do is respond to subpoena requests and pull up deleted messages and texts and emails. As a manager, please always remember that what you put in written communication is always going to be out there. It's a permanent record. I stress this with employees as well, almost to the point of scaring them, because it is so important to remember before you hit send, is that a message that I want out there forever? Email is a tad bit easier, because with email, you have more space to communicate your thought, right? You're not dealing with brevity. Text is much more difficult, because usually you're not texting a novel, although some people do, but it's usually more short and sweet and to the point. The problem with text and email is tone, and tone can get completely lost. I can't tell you how many times my husband and I have gotten into a fight because I will text one thing and have I'm just saying this kindly over text, but he'll read it with a different tone and be, angry. So we've seen a lot of clients do a couple things. They'll develop no texting policies, which isn't necessarily a bad idea. It works for some clients, doesn't work for others, just to avoid this issue. Maybe it's no texting at all, or maybe it's simply you don't text clients. Email, again, is something we're going to live with. Email is always going to be a constant form of communication. We're never going to avoid email. But what we should do is, especially as managers, please make sure that you are not emailing sensitive information, number 1, or trying to have difficult conversations over email. We can still pick up the phone these days. Now with Zoom or Teams, you can have face-to-face conference calls. Have those difficult conversations with employees on the phone first, over Zoom first. Be mindful that if you do it via email, an employee or other manager, whomever you're communicating with, may read it with a different tone, or that message may be lost. One-liner that we talk about at the very end of the presentation, but it's something I think is really helpful to remember kind of in the back of your mind all the time. And it doesn't just pertain to text or email, but in general, to think about before you say or do or write something, to think about, is this something that I would be uncomfortable doing or saying or writing in front of my child or my spouse or a good friend or a parent? Would I be embarrassed if they saw me do or see or write this? And if the answer is yes, then rethink how you've written it, or don't say something that way, or rethink that behavior. I use this when I talk to the employees as well. It's just a great one-liner to keep in the back of your mind when you're trying to remember how to be professional, how to conduct yourself with professional decorum in the workplace. Is this something I would be really offended that my daughter or my mother or father saw me do or say? Okay, if yes, then I need to rethink what I'm about to do. And so that applies to texting as well. Be mindful also, it's kind of a side note, but it's important, that if you text employees and you're not paying for their cell phone and it's work related, they could make the argument that you need to compensate them for their texts, for their phones. If you're texting them after hours, and this is for non-exempt employees, they could make the argument that they need, if they're being required to read that text after hours, that might be compensable time. So I'm not a huge fan of texting employees, especially non-exempt employees. I know that, especially right now, it's a lot of companies are reliant on it, but you know, I would encourage you all to try and shift away from that. Again, utilize more email or phone calls, but something to be mindful of. My slides don't want to work today. Okay, we've talked about this. So when you look at protecting the work environment, as we've said, vendors, customers, clients, job applicants, anyone who comes into contact with your business has a responsibility to be professional, right? You have to protect your employees from those individuals, but it also goes the other way. You have a responsibility to protect anyone who comes into contact with your business from your employees. So who's protected from unlawful harassment? Well, obviously your employees, job applicants, independent contractors, third parties, customers, vendors, etc. And again, this is just a visual representation that they can also be potential sexual harassers. I want to talk for a minute about customers and clients because I get this question a lot. Let's say, and I had this with a client, they were a firm, and as a firm, 90% of their business came from one client. And unfortunately, that client was very inappropriate with some of the firm's employees. Now, what were they supposed to do, right? They couldn't allow their employees to continue to be harassed by this client, but this is the real world. This was 90% of their business. This wasn't as cut and dry. Yes, theoretically, they should say, we're not going to tolerate this and terminate that relationship with that client, but it's 90% of their business. So these, you know, again, I want to point to, I recognize that I'm here with this lovely PowerPoint, but I understand that transferring this to the real world is messy, it's gritty, it's difficult to navigate. And in this particular situation, the solution was they needed to keep that client. The solution was that the client only interfaced with one of the partners. Only one of the partners of the firm continued to have direct communication with that client. Because again, they needed that client relationship, but also had an obligation to protect their employees. When I was in the federal government, the agency was a healthcare provider. And as part of a healthcare organization, we had a large mental health program. and we had a large group of very ill patients who were very mentally ill, and as a result exhibited behaviors that were inappropriate or even sometimes threatening to our employees, to the medical care providers. We could not just turn those employees out onto the street and say, too bad, we're not going to provide care to you. You're being rude or inappropriate to our employees. We also had an obligation to serve those patients. So again, very similar situation. It's not always cut and dry. In that particular situation, every incident was unique in how we handled it. Whether it was reassigning them to a different medical care provider who was more equipped to deal with the behavior, or perhaps for whatever reason was the patient was less likely to be inappropriate with them. But my point is, sometimes it's very easy for the PowerPoint to say there's zero tolerance. We're not going to allow a customer or vendor or client or patient to be inappropriate in any way. And sometimes it's not as easy as that. Now, you have to 100% protect your employees. That you have to do. You can't just say they're an important client, they're an important patient, we're gonna just have to deal with it. You can't do that. You do have to protect your employees, but it may not be as cut and dry as cutting that relationship with that vendor or client. So we've defined harassment, we've talked about who is protected, who is liable. Even if you take all the right steps to try and protect your work environments, you provide all the coaching, you have your open door policy, sometimes harassment still occurs. It just does. If it happens, who's liable? Well, first and foremost, employers are, right? Dual employers. But individuals can also be named on suits. They can also be held personally liable for sexual harassment, meaning you as managers, you could personally be named in a suit if you have not acted appropriately, right? Now, most of the time lawsuits go after the company because the company has deeper pockets than an individual. But if you were negligent in your handling of a situation, and we're going to talk about that in the next couple slides, so I don't want to worry you at this point. But if you are negligent, technically you could also be liable. So as I mentioned before, managers need to be proactive in monitoring the environment because unfortunately, many employees don't report the harassment, okay? It would be nice if we could rely on it, but sometimes they don't. Most of the time they don't, right? So there's the fear of being labeled a troublemaker. Why would I report something? Maybe I'm new to the company. I don't want to, create or sour my reputation. I don't want to be known as a troublemaker, so I'm just not going to report it. Or maybe they're afraid of losing their job, right? Which again, when we saw prior to the recession in 2008, people were less likely to report harassment. This is the one that I think is the most, is what we see the most in terms of why people don't report it. It's my word against theirs, because so much of harassment is simply between two employees. Rarely are there witnesses, and we'll talk about the importance of dealing with witnesses. So obviously, if I report, let's go back to the Jen and Joe situation, Joe may think, I'm not going to report it. No one else saw Jen badgering me about wanting to go on a date. She's just going to deny it. So what's the point? This is the most common. And I stress this with the employees when I do the presentation, that you're still protected as an employee. Just because it may be they said, doesn't mean a company still can't review the situation. And we'll look in a few slides about when you do an investigation and you run across this, are there other things you can refer to? If there's a pattern, let's say with the Joe and Jen example, maybe there's a pattern of Jen harassing other employees. You may rely on that and say, based on that pattern, we are going to make an assessment on the evidence that we have that Joe is being truthful in this allegation. So there are ways to navigate around the situation where it's my word against theirs. So as I've said, as an employer, as a manager, you have two responsibilities, right? And that is to prevent harassment. And if you can't prevent it and it occurs, you need to correct the harassment. So employers can be liable for conduct in supervisors and managers, and employers can be liable for sexual harassment by, again, a coworker, vendor, customer, visitor. Here's the most important part for employers. So anybody who's multitasking right now, pay attention to this. Where you are liable is if the organization knew about the conduct and failed to take immediate and appropriate corrective action. Just because harassment occurs doesn't automatically mean you're going to pay out. Okay, so when an individual files a claim, what they have to initially show is that the company was aware of the allegation and didn't act appropriately, did not act accordingly. So if you have a situation where you have two employees, there were no witnesses to it, okay? We'll stick to the Jen and Joe situation. Joe did not report the harassment to anybody. No one witnessed it. There were no rumors. There was no way for management to know that Jen was behaving this way. If Joe tries to claim that the company didn't respond appropriately, that claim likely will not be substantiated, right? Because how can a company do something if they're not aware? Now, it doesn't mean that the liability kicks in when Joe tells their manager about the allegation, right? Doesn't mean that all employees have a responsibility to report it directly to the manager. We hope that they will, but if Joe can prove that other people witnessed it, maybe they told another supervisor, not their own supervisor, if there was enough to show that the company reasonably was aware and turned a blind eye, that's where you're liable. The other piece, okay, even if harassment occurs and the company knows about it, okay, so let's say now the company is properly on notice, still doesn't mean you're necessarily liable at that point. You also have to ignore it and fail to take appropriate corrective action. We're going to talk about exactly what you should do. So if the company is aware of the allegation from Joe, understands Joe's concern, and immediately responds, separates out the employee, does the investigation, takes appropriate corrective action, then they probably are not going to be liable. They've acted accordingly. So those are the two pieces to be concerned with. There has to be reasonable proof to show that the company was aware, whether it's the employee reported it or there was enough information to really show that a manager witnessed it or they heard what was going on. There's got to be some case to substantiate that. And that they also ignored it and did not act immediately. Before we talk about the actual process, I do want to talk about the two broad categories for sexual harassment. And I know we have half an hour, so I am mindful we will get through these slides. So we've talked about the 5 types of harassment, but they fall into 2 categories. The first one being quid pro quo, and the second being a hostile work environment. Quid pro quo, it's Latin. It means something for something or this for that. It's the most obvious form of harassment, and it was nicknamed in the 1920s as the casting couch effect. The idea that perhaps a particular actress or actor who wanted a part in a movie would offer sexual favors in return for that role. That's where the nickname came from. It typically occurs when a person with the power to influence an employment decision or condition seeks a sexual favor in return for a positive outcome. So prior to 2017, we really thought these were the more extreme cases, and we really didn't see that many of these allegations. And then what happened, right? All of a sudden, news stories broke out about these extremely egregious forms of quid pro quo harassment that are occurring in society as well as in workplaces. I always refer to the Matt Lauer one just because it's so outrageous. I won't share the details, but if you're familiar with that case, it's so outrageous what occurred. And obviously, employees are strictly liable for that. So some examples: Sandy's manager, Matthew, asks her to have dinner. She declines. He asks again, saying there might be some discussion over dinner about a new role. She's torn, but she accepts because she wants the promotion and doesn't want to jeopardize her chances. So clear example of quid pro quo. Second example, Danielle's boss, Christine, makes frequent flirtatious comments because they are alone. He ignores the comments because he needs the job. She asks Daniel to stay late one evening to work on a project, asks him to give her a back massage, and makes suggestive remarks about taking things further and telling him that he may be able to avoid layoffs in the future. Another very obvious form of quid pro quo. So some other examples: supervisor requesting sexual favors as a condition for hiring, promotion, advancement, or a manager threatening to terminate, transfer, demote, or otherwise adverse affect an employee's work life if favors are not given. Supervisor promising or giving an employee a raise or promotion, or even a director saying to an employee that we'll give you a favorable assignment or even a spot at a convention in Hawaii with the expectation that the employee will repay with sexual favors. So the second type of harassment is hostile work environment. This is when an employee is subjected to sexual advances, requests for sexual favors, other verbal or physical conduct of a sexual nature, or where non-sexual abusive conduct imposes a greater burden on one sex than the other. Obviously, the conduct is unwelcome, and the conduct is sufficiently severe or pervasive to have some type of impact. So remember at the beginning of the presentation when I talked about there needed to be either the impact to an individual's working environment, into their performance, or into their position, their employment. But with a hostile work environment, there's a fourth area of impact. So we'll go back to the example with Jen and Joe. Joe doesn't quit. He needs his job. He's somehow able to maintain his performance. He compartmentalizes and is able to focus. No one else witnesses the behavior, so it's not impacting the work environment. But it doesn't mean that it's not impacting his psychological well-being. He might be losing sleep at night. He might be anxious. He might start to see a therapist. He's so distraught over the situation. So it's impacting his psychological well-being. So when you look at hostile work environment, it's important to remember sometimes you may not see the impact. It's very easy to see somebody who is quitting or having poor performance or another individual who's complaining about the environment. But if you don't see those three components, those areas of impact, it doesn't mean it's not a hostile work environment. Because what you may not see, what's more difficult to see, is what's actually impacting the victim's psychological well-being. So as I said, there was one graph and one case in this presentation, and that is Ellison versus Brady. and it developed the reasonable woman standard. And this was back in the early 90s, which then very quickly shifted to the reasonable person standard. So a little backstory on this case. Carrie Ellison was an IRS agent, and she worked for the Internal Revenue Service. And one day her coworker Brady asked her to lunch. She declined. And from that point, things escalated. Brady kept trying to engage with Ellison, sent her letters, because again, this was back in the early 90s. And she reported it to her supervisor, tried to deal with it internally, and her complaints were ignored. She filed it initially as a complaint of harassment, and it was denied, right? They cited that it was one incident and it did not rise to the level of a hostile work environment. She continued to appeal that decision, and it went to the California Ninth Circuit Court of Appeals. I want to read to you very quickly because I think it's fascinating, the ruling. What they said in the California Ninth Circuit Court of Appeals is, we realize that there is a broad range of viewpoints among women as a group. And I'll pause for a second. This case surrounded the female perspective, but again, as I said, it quickly shifted to a reasonable person standard. So we'll talk about how this is going to apply to non-gender in just a moment. But we believe that many women share common concerns which men do not necessarily share. For example, because women are disproportionately victims of rape and sexual assault, women have a stronger incentive to be concerned with sexual behavior. Women who are victims of mild forms of sexual harassment may understandably worry whether a harasser's conduct is merely a prelude to a violent sexual assault. Men who are rarely victims of sexual assault may view sexual conduct in a vacuum without a full appreciation of the social setting or the underlying threat of violence that a woman may perceive. We cannot say a matter of law that Ellison's reaction was idiosyncratic or hypersensitive. We believe that a reasonable woman could have had a similar reaction. So again, this was from the early 90s, and it has shifted. I know right now it's speaking a lot about a women's perspective. So what the case was saying in the early 90s is, Ellison filed this complaint about her perception of this behavior. And those who were ruling on this case were male. And that we had to understand that at the time, male and women, or male and female, had a different perspective, because at the time, again, women were more likely to be victims of rape and sexual assault. Statistically, that's what was occurring at the time. And because of that, because women were more prone to these violent attacks, we therefore perceive behavior differently than a group of individuals, in this case male, who were not as prone, again at the time, to these assaults. The idea being, when you look at a particular behavior, before you can rule on whether that behavior is harassment or not, you have to understand the perception of the person who was the victim of that behavior. So again, if you have a group of male judges ruling on this who aren't able to take into account this female's perception of the behavior, you can't rule equitably, right? So that's what this case was saying. Now again, it has very quickly shifted to a reasonable person standard, with the idea whether it's gender or race, that you have to consider when you look at a behavior, the individual's perception. And an individual's perception is very much colored by who they are. And that is very important for the courts to take into consideration. So it was a landmark case. I know it comes across when I read it as only referring to female, but it does now apply to a reasonable person standard. And remembering that, because everybody perceives things differently, and we want to fall into, again, reasonable standards, okay? not those outliers. Where are we with the reasonable standard, but also taking into consideration the individual's perception and who that individual is. So non-sexual gender stereotyping is also a form of harassment, right? Negative gender-specific comments can also lead to claims of sexual harassment in the workplace. So statements such as, that's a man's job, a woman could never handle it, women are too sensitive to handle pressure jobs, or men are pigs and can't be trusted. Can you say these things? No, right? Absolutely not. Can you make positive gender-specific comments? Can you say things like, females are really great multitaskers, so that's why I'm going to put Sally on this job. Or men tend to be more athletic or strong, and so therefore we're going to have John on this project. Can you say things like that? No. Could you have said those comments maybe 5 or 10 years ago? Maybe, right? We constantly evolve as a society as to what's appropriate and what isn't appropriate. The reason I want to talk about this tangent quickly is because you may, as a manager, experience an employee who makes a comment, perhaps by saying, oh, females are very good multitaskers. That maybe a few years ago was more socially accepted, but now is not. And you may think, oh, well, hopefully they just don't say it again. Just ignore it. I know they didn't mean harm by it. But that may offend other individuals, right? Because we're constantly evolving, and unfortunately, at the start of each year, there isn't an update to the world or to the country about what is now no longer appropriate to say, you're going to run across a lot of individuals who may have missed that memo. And it's important for you as a manager to try and correct it when you hear it. Again, going back to that example of the manager who was proactive in dealing with the employee who visually looked in a certain direction. If you address it right away, they most likely are not going to realize that what they said was inappropriate. Probably apologize and then correct it. I know it's difficult, but really the more proactive you can be in dealing with those small instances, you're going to protect yourself from much larger issues in the future. I'm going to skip through some of this in the interest of time, but sexual harassment can occur in a variety of circumstances. So the victim as well as the harasser may be a woman or a man. Victim does not have to be of the opposite sex. So again, gender does not play a role. The harasser can be the victim's supervisor, an agent of the employer, or a supervisor in another area, coworker, right? Anybody that comes into contact with the business. Victim does not have to be the person harassed. It could be anyone affected by the offensive conduct. So this is important as well. Looking at the example with Joe and Jen, maybe John oversees those interactions and he's offended, right? He could file a harassment claim. Unlawful harassment may occur without economic injury to or discharge of the victim. And obviously, the harasser's conduct must be unwelcome. So we've talked about your liability, right, and your obligation. Employers must take, number one, all reasonable steps to try and prevent discrimination and harassment from occurring. So we'll look at some strategies in a minute. So sometimes managers think that they should focus the majority of their efforts to knowing what to do when harassment occurs, being very strong in that component. But really, I would encourage you to shift that focus, that really be experts in trying to prevent it, right? Because that's what's going to save you time and money. And then obviously, even if you take all the right preventative steps, harassment may still occur. And when it does, when an employer is aware of an allegation of harassment, again, this is where you're liable. When you're aware, you must take immediate and appropriate corrective action immediately. So what does that look like? Well, first and foremost, you have to figure out what happened. You have to do your investigation. So let's go back to that example with Joe and Jen. Joe comes to you on a Friday afternoon at 4 o'clock, lets you know what's going on. Can you deal with it on Tuesday? Can you just say Monday's a really busy day? We'll address it on Tuesday. No, unfortunately, you have to stop what you're doing and start the process that moment. So the most critical piece is separating out the two individuals. And there's a lot of different ways you can do it, but that's the most important part, is making sure that once you're on notice that there's been some type of alleged behavior, that you separate the employees so that behavior can't continue. Now remember, you've only heard one side of the story, so you can't draw any conclusions. You can't say to Joe in that meeting where he's explaining what has happened, oh, I'm so sorry that happened to you. Jen has a history of this. She's a terrible employee. You know, absolutely, we'll fire her. You can't say any of that because you don't know what's happened. You also, when you separate the employees, have to do so without harming either employee. So you can't just send Jen home, right? Even if you're paying her, because the courts have shown that even if you pay somebody but you send them, you're not allowing them to work, that's harmful to the employee. Because you don't know that she's actually done anything wrong at that point. So you have to be creative. So some things that you can do are maybe try and have employees work in different offices, maybe move some, have them work at different times, but you try to do so equitably with both the individual who's filed the complaint and the alleged harasser, because at that point you don't know what's what. My previous experience, we were the queen, or I was the queen of creative details. So when I had an allegation, because I wanted to protect the other individual, we would administratively assign them to another project based on their skill set. Because we didn't want employees talking as much as we could. We wanted to protect the rumor mill. So that's always an option as well. So sometimes you have to be a little creative with your solution. Once you've separated out your employees, then you have more time. And you can take time to properly investigate. That's getting witness statements, interviewing the alleged harasser as well as the alleged victim. We really encourage you to have either an HR department do it, or an outside consultant or a lawyer. You definitely don't want the manager doing this themselves, especially if it's a pretty egregious allegation, because you don't want the illusion of any bias. Once you've done the investigation and you have all your facts in front of you as best you can, or your evidence, then you decide what steps you need to take. If you corroborate the harassment, you may end up having to terminate the harasser, discipline them, permanently reassign them. There's lots of different options. But that's kind of the three-step process. Separate the employees, do the investigation, take appropriate corrective action. In California, there's also some requirements to post notices, okay? So EEOC requires employers post a preventative notice and advise employees of their right to harassment-free workplace. And California takes it a step further, and you actually have to give them a pamphlet. Usually this is done when they're hired. We've talked about how to handle when a complaint has occurred, right? When there's an allegation. But what are the steps that you can take to try and prevent harassment? What are tangible steps that you can do? You want to issue a formal written sexual harassment policy and grievance procedure. Hopefully all of you have this in your handbook already. It's very crucial that this is implemented and that your employees are aware of it. Establish a complaint process that provides for prompt, thorough, and impartial investigation. Make it a regular practice to talk to your employees and ask them about their work environments. This is really helpful if you can do it, especially now that we have remote work sites, and it's not as easy to walk down the hall with a cup of coffee and say, hey, how's your week going? You know, you need to do your check-ins with your employees, especially since you can't see them. I can't stress this enough. Please always encourage your employees to come forward regarding any concern they have. Reiterate your open door policy. And obviously, take complaints seriously, right? No matter, and this is again why we encourage managers not to do the investigation, because they're so ingrained in the team, they're going to inevitably have biases. But no matter, you may look at a complaint and go, I know this is not valid. Absolutely know this individual is lying through their teeth. You still have to take every complaint and investigate it like it's coming from your best employee. So again, review your company's non-harassment policy in your handbook. So the last two topics that I want to talk about in the last 10 minutes are bullying and retaliation. So bullying is defined as workplace conduct with malice that a reasonable person, so there's that term again, reasonable, would find hostile, offensive, and unrelated to an employer's legitimate business interest. So things like derogatory remarks, insults, verbal or physical conduct that a reasonable person would find threatening, intimidating, or humiliating. The gratuitous sabotage or undermining of a person's work performance. This has definitely shifted over the years, how we provide feedback to employees, especially in a public setting, when we're meeting with teams and we're talking about ideas and reviewing performance. We need to make sure we do so professionally and we're not doing it maliciously. I think there was a few more, perhaps not. Some other common signs of workplace bullying, right? If your employer or coworker exhibits verbal anger or aggression, or nonverbal aggression, slamming things on your desk, slamming doors, punishes you physically, psychologically, or emotionally, belittles you, again, going back to how you provide feedback and critique, humiliates or embarrasses you, acts vindictive, or threatens you with unwarranted punishment, termination, physical, emotionally, or psychological abuse. So again, it's malicious behaviors that can include the repeated use of derogatory remarks, right? A single episode or incident is usually not considered abusive, right? Unless it's especially severe or egregious. Now, it doesn't mean that one incident still can't be inappropriate in a hostile work environment. It just means usually with abusive conduct, to fit that term, there's usually more than one episode. I encourage you to not just remember that abusive conduct is illegal and inappropriate, but as managers develop their management style and how we coach and how we provide feedback and how we manage our employees. The old school way was very authoritarian, right? Do this my way or else, and I'm going to be harsh with my employees and I'm going to drive a hard ship. Those types of behaviors, those methods, number one, border bullying and are therefore inappropriate, but they're also not very effective, right? When you manage that way, you're not creating a healthy environment, right? There's a lot of negative effects of bullying in this type of authoritarian management style, right? It's not helping productivity, it's not helping morale. So kind of remember both pieces of this. It's not just, I'm not allowed to manage this way. It's also a really poor management strategy, right? So there's no law against abusive conduct. It just gets looped into hostile work environment, right? So be very careful with your words and obviously your email or text. We talked about this. Don't discipline or dress down an employee by email or text, have those conversations face-to-face or via Zoom, verbally, and be sensitive about anything you see or hear that might be considered abusive conduct. We've talked about the grievance procedure. Take all complaints seriously. Don't ignore a complaint. Don't discount claims made by troublemakers. And supervisors must take reasonable care. So again, when you are on notice, you must act immediately to separate, do the investigation, and take the corrective action. Okay? Do something when you learn about harassment. Go to your HR if you have an HR department. Remember, you're responsible. You have to pay attention. You need to be proactive. Again, we've talked about the investigation procedure. Encourage victims of harassment to report the behavior. We know that that's not going to be a fail-safe, that there will still be times when employees won't report it, but continue to drive home that you have an open door policy, that they can go to HR, that there's lots of different management options that an employee can go to. In your grievance procedure in your handbook, your harassment policy, you have to make sure you identify more than one person to whom the behavior can be reported, just in case they're uncomfortable with that person or that person is the one who is harassing them. You have to have multiple options for the employees to report it. Apply the policy neutrally and consistently. And the last topic that I want to talk about in the last 4 minutes is retaliation. We explained this at the beginning of the presentation. It's when an employer takes some type of adverse action against an employee because they either complained of unlawful harassment. So if in the Joe and Jen example, Joe receives a poor performance appraisal because he had complained about Jen's behavior, because they participated in an investigation. Now let's say, again, the Joe and Jen example, John was a witness. He was able to confirm that what Joe was saying was in fact correct. He saw Jen repeatedly go to Joe. Now John all of a sudden has a poor performance appraisal or demotion, or even they changed his parking spot, anything. He may be able to claim that he's being punished because of his participation, right? Even if they don't participate, if they're vocal about their sympathy for an individual, or they simply have a strong relationship, maybe Joe and John are very good friends and the company knows that and they want to punish Joe, so they're going to punish John. They may be able to make that claim. So again, thinking back to the slide, we talked about all the categories for discrimination, and I probably scared you all. And we said there's a lot of ways that an employee can claim discrimination. There's a lot of ways an employee can claim retaliation. Does that mean as a manager, you shouldn't actively manage your workforce? Absolutely not. If John deserves to be demoted, even if you think, well, I know he's going to raise the allegation of retaliation, do you still take the action? If you have justification, if you can show whatever action you're taking against John is because of poor performance, right? What are the two reasons that we affect some type of action against an employee? The employee's performance or conduct, or the general needs of the business, right? So very similar. There may be times where you see a retaliation claim, but as long as you're protecting yourself by having the documentation to support the reasons why you took that claim or that action was because of the needs of the business or the employee's performance or conduct. Okay, just a few last slides in the last 30 seconds. Remember that you set the tone as a manager. So obviously, if you see things, take down offensive jokes and cartoons, counsel employees, If you overhear things, deal with it right away, right? And obviously don't participate in inappropriate conversations or laugh at jokes, no matter who tells them, right? You are a role model, you set the tone and you say it's not okay. Things not to do: if you get a complaint, don't say that it is trivial, right? Or that somebody may have misinterpreted the facts. I know that's in your human nature to want to make the person feel better or find a reason that it occurred, but don't express opinion on it. Don't ignore it or conclude that it is not your place to do anything. Don't discount claims made by troublemakers. Just a few what would you do scenarios in 10 seconds. If you receive a sexual joke as an email attachment from a coworker, obviously you're going to tell the coworker that it's inappropriate. You're going to make sure that the coworker has not sent it to anybody else. And you're also going to discuss with those who have received it, go to those individuals, don't forget about those individuals, and let them know that you've handled it. That if they've been offended by what they received, you're handling it, and that these types of electronic communications are not appropriate. So which of these behaviors would you consider sexual harassment? Making unwanted sexual overtones, telling sexually explicit jokes, touching a coworker suggestively, male or female bashing, right? Probably all of them. But there also might be some common excuses. It's a simple misunderstanding, poor judgment, ignorance. But is it still harassment? Absolutely, because it is not the intent, but the perception. So again, the guideline that I referred to, what offends one person may seem funny to another, right? So remember, is this something that you would do or say in front of your child or family member or close friend? And we're going to skip these claims because we have already talked about them. The last slide, just some overall excellent HR tips. Treat your employees well. Now more than ever, everybody is struggling. Please be mindful of it. Take time when you talk to your employees. Take a minute out of the day to ask how they're doing, both personally and professionally, right? Happy, engaged employees tend not to file lawsuits. That is absolutely true, right? Or workers' comp claims or create problems. So be proactive in making them feel appreciated, making them feel they're in a safe environment. And then obviously the flip side is don't ignore problematic employees, move quickly against them. Our experience is that most employers are afraid to do that. It's difficult, it's not fun. But if you ignore it, it will only exacerbate the issue. Address the problems immediately and don't wait. And the last slide is just two pictures, both of which you can see two different things. And the one on the left, you can either see a young woman or an old woman. The one on the right, you can either see a picture of Marilyn Monroe or Bill Clinton playing a saxophone. So again, just a visual reminder that we all see things differently and that it is not intent but perception. So I apologize for having to rush through the last few slides, but rest assured we did cover all of the topics. I hope that today was valuable and somewhat enjoyable. I am happy to stay on and answer any questions. I know that Diane will be providing you my email. If you have any follow-up questions either today or things you think of in the future, I'm happy to address them. And I really appreciate everyone's participation and time today. I know we all have quite a bit going on, and I really appreciate your time and attendance today. So with that, Diane, I'll turn it back over to you.
Devin, thank you so much. We appreciate your continued partnership in providing this training to our clients complimentary. So thanks so much for that. And I just want to let everybody know that we did record this session and it will be posted to Hoffman Brown's YouTube channel probably by tomorrow. And with that, thank you so much for attending. That is the end of the webinar.
Thank you so much, everybody.